All right, we're back on the record in the Johnson versus Johnson
And here we go. The Battle of the Johnsons. Forget courtroom dramas on Netflix. This is real-life high stakes. Money, betrayal, and a retirement fund vanishing faster than you can say irreconcilable differences.
this is here, if I understand correctly, on your motion to alter or amend the final decree.
That is correct.
You wish to make an opening statement?
Just very briefly, Your Honor. We're basically here. So the parties were divorced. There had been a divorce complaint filed in October of 23. The parties had separated in April of 22. So at least a year and a half or so, they were separated before the divorce complaint was filed. Of course, the wife was the petitioner in this matter. Mr. Johnson was not aware of the court date. The court date came, and there were certain findings that were incorporated in.
Quick legal insight. A divorce decree isn't just paperwork. It's the law of the land for the ex-couple. Think of it as the official scorecard of who owes what, who keeps what, and who's walking away a little salty.
Your Honor, we're essentially here on 5 issues, and those issues are that the wife, Mr. Johnson, withdrew his Vanguard retirement in 22, a year or so prior to the divorce even being filed. So he withdrew his retirement, and that amount, Your Honor, was $56,152.73. As Your Honor knows, there are taxes.
Oof, that a very specific number. And anytime the court throws around exact dollars and cents, someone's accountant is sweating. And yes, we're about to dive into taxes, penalties, and why early withdrawals are divorce lawyers' nightmare.
Withheld from the retirement, and then at some point, he has not filed his 23 taxes yet. I do believe he's filed his 22, but I'll clarify that with my client. But there will also be a 10% early withdrawal penalty that would be assessed. So within the terms of the divorce decree, the wife was granted a judgment for 1/2 of the whole amount of the amount that was withdrawn, which in reality, that's not the amount that was received. If she received 1/2 subsequent to the taxes being paid, which the taxes were withheld prior to Mr. Johnson receiving any money, and then the 10% penalty, she would only be entitled to $19,653.46. And I would submit, Your Honor, that the proof will show that it's only fair if she's going to receive half, she should receive half of what actually was realized. And it will also be our position today, Your Honor, but for those monies being withdrawn by Mr. Johnson, what got paid by Mr. Johnson would not have been able to have been paid by Mr. Johnson but for those monies. So she's already benefited from those monies being available. Mr. Johnson was the only party who made any house payments from the date of separation on April 22nd until the date the house sold. We have no evidence. We would submit that will be, I do not believe there will be any evidence submitted that will show that Ms. Johnson paid one house payment. Also, Your Honor, the proof will show that between the date of separation and the entry of the final decree of divorce, that Mr. Johnson paid some $94,000. Let me make sure that number is correct. Between $89,000 and $94,000 in payments: house payment, pool payment, car payment, sport.
Notice a defense strategy here. Stack up every single payment ever made and hope the judge sees it as proof of being the responsible parent. It's less about generosity and more about building a financial paper trail that screams, "Look, I supported them already."
Fees for the parties' children, medical payments, medical insurance, vision insurance, dental insurance, direct payments to the wife, payments for items requested that they be purchased for the house and for the children, and then direct payments to the children. And so, Your Honor, what we're asking Your Honor to do is to take those payments into consideration when it comes to whether or not the judgment in regards to the Vanguard account, whether or not that will stand or will it be reduced. Child support arrearages were calculated in this case from the date of separation through the date of entry of final decree of divorce. And the amount of the judgment that was entered was $26,016. And Your Honor, we're asking that that be reduced today to zero. Again, Mr. Johnson paid over $94,000 in expenses that benefited the family and the children. And those should have been presented on the day that the hearing was held. The court did not have enough information to simply just reduce a child support arrearage judgment. And also, Your Honor, the complaint for divorce did not request that the arrearages be calculated retroactive to the date of separation.
Child support payment at any point during this pendency of this case?
No, Your Honor, not during the pendency. There was no child support calculated whatsoever until the default hearing. So, Your Honor, our position is that Mr. Johnson should have received credit for what we routinely call family support, and that in fact there should have been no retroactive child support arrearages. And if the court does deem that there should have been, then Your Honor, we would ask for it to be recalculated from the date the complaint was filed, which was October 11 of 23. Instead of going back to April of 22. And we're also asking for it to be recalculated, applying insurance credit as the calculation that was arrived at did not have any insurance credit. And Mr. Johnson was in fact insuring. At that point, it would have been 2 children and then subsequently the youngest child. And then, Your Honor, as far as the current support that was calculated, it would be our position that that again needs to be recalculated, applying the insurance credit in the calculation. And that calculator, the child support worksheet, gave Mr. Johnson 0 days and the wife 365 days. Mr. Johnson was available to have these children in his care. Now, they weren't.
Here's an emotional twist. He's arguing I could have had the kids if they want to come over, but courts usually care about actual time, not hypothetical parenting. Audience check-in should be an available count as parenting, or is that like keeping a guest room ready, but never actually hosting anyone?
And they didn't visit. They were older children, well into their teens. And I mean, this was a tenuous situation, but he was available and it was just...
Being available, does that count as a day under the child support guidelines?
Often, I will say this, the child...
Agree with it or not, is that by definition a day that...
I don't know that it is, but certainly it's punitive if you simply, say he gets no days. He could have visited. He would have liked to have visited. In fact, there were days where he did take at least one of the children to ball games that were out of town, and so he did spend some time with the children. And then, Your Honor, we have the issue of whether or not Ms. Johnson is entitled to any funds that were in arrearages as far as the house payment. Mr. Johnson was ordered to bring the mortgage payments current within 60 days. He did not have the ability to do that. And then to get into the calculation as to how much principal would there have been if he had paid if he had brought every payment current within those 60 days versus how much was the payoff of the home when the property sold. And I don't think there's anyone here today that's qualified to testify as to what that difference would have been. So anything that was owing on the home was paid when the property closed, when it was sold, and that was paid right off the top. So they've already each paid half of those, which in my position would be is that that's equitable. And that's what the court's mandated to do, is to make an equitable division of the marital property and the marital debt. And so just assigning everything to the husband because he wasn't in court on the day the hearing was held, that is not equitable. So all we're asking Your Honor to do today is to go back and look at these issues, and based on
Translation, you want a legal redo. But courts don't hand out second chances just because someone didn't show up last time. The standard is high. Error, injustice, or flat-out legal mistake. Otherwise, tough luck.
the proof that's going to be before you today is to amend the final decree of divorce so there is an equitable division, and to amend those child support arrearages to zero based on the support that Mr. Johnson paid from date of separation through entry of final decree of divorce.
All right.
Yes, Your Honor, if I could just briefly. I represent Ms. Johnson in this matter. And as Ms. Salinas stated, these parties separated in April of 2022. The parties had 4 children born of their marriage. Mr. Johnson left the marital residence. The testimony will be that the basis of the divorce on the grounds of inappropriate marital conduct was Mr. Johnson's solicitation of prostitution.
Veal. And there it is, the bombshell accusation. Infidelity plus spending marital funds on it. In divorce law, that's like throwing gasoline on the fire. Not only does it wreck trust, but it can seriously tilt the scales in property division and spousal sympathy.
And frequenting and having extramarital affairs and using marital funds to satisfy his sexual proclivities. So again, that's relevant in the fact of that there was significant grounds for divorce in this case. And he had been gone from the home, and he had left the home in April of 2022. And at the time, the 4 children were in the home. At the time, the children were 18. The youngest one just graduated this past May and turned 18 in June of this year. So the complaint was filed, the divorce was granted on the 3rd day of April. And in that divorce decree, Your Honor, in 2024, Mrs. Johnson was granted divorce on the grounds of inappropriate marital conduct. And again, it was the marital residence was to be sold and the proceeds divided equally between the parties after the payment of the indebtedness, cost of sale, and loan on the pool. That's important to note because on the same day and date that my client was appearing in court before Judge Lockhart Mash, Mr. Johnson, the testimony is going to show that Mr. Johnson borrowed an additional $20,000 on the home and forged Mrs. Johnson's signature on that and had his aunt notarize the signature.
Forgery alert. This is no longer just a messy divorce. It's flirting with criminal territory, borrowing $20,000 and faking a spouse's signature. Judges do not take kindly to that little side hustle.
On that, and he acquired $20,000. So again, the proof is what did he do with that $20,000? Because during the pendency, after the divorce was granted and Mr. Johnson retained Ms. Salinas and he filed a motion to set aside the final decree, the payments became significantly delinquent and the property was in jeopardy of foreclosure. In the fact that it was going to be, the property was supposed to be sold back in April of 2024, Mr. Johnson, who had historically, and the testimony would show, had historically paid the mortgage and the pool payment, that he would continue to do that. And he would bring any payments current within 60 days. And he would provide proof within 10 days to do that. When we came back to court in October on the motion to set aside the default that was amended pursuant to the order to a motion to alter or amend, the house was finally sold, and the money has been deposited into court, and his half of the money has been deposited to the tune of about $78,000. In addition to that, Your Honor, the judgment on this is that the wife was to receive judgment in the amount of $28,076.36, which represented her half of the retirement account from Vanguard. In 2022, during the separation, after they had separated, but before the filing of the divorce, Mr. Johnson withdrew some $56,152.73 from the Vanguard account. And again, there would have been a qualified domestic relations order, and she would have gotten half of that, and there would have been no taxes. He unilaterally withdrew it and had to pay $11,230.54 in taxes, according to the 1099-R form that was submitted through his company. The retirement account was with Vanguard through CVS Health, and as of the date of 12, it had lost some money from market gains and losses through 2022, and he cashed it out. And as I said, that amount that he received was some $56,000 and some change, and she was entitled to half of that judgment. And again, we've got the 1099 to illustrate what he got. So if it had been there, then she would have had that rolled over. Historically, what the court needs to understand is that these parties had a long-term marriage. They were married in 1998. They had 4 children. For the most part, my client was a stay-at-home parent. She went back to nursing school in 2010, I believe it was, is when she started, 2014, excuse me. She was a stay-at-home mom and worked as a tech, but she started nursing school in 2010, graduated in 2014, and began working in 2014. So for a big significant part of this marriage, she was a stay-at-home parent and did not have, was not the primary breadwinner, and she did not have a retirement account. So these funds were crucial to her to fund a retirement when she reaches that age. So again, to ask for an offset for taxes for him unilaterally cashing it out. And the question would be, is as Ms. Salinas has stated, he's not filed his 2023 taxes nor his 2024 taxes. So they come to court on a motion to alter or amend, not fulfilling their obligation to produce their income. There's no tax records to be filed because he hasn't filed it. And again, I'm standing here and I apologize for not knowing because it wasn't provided in discovery. I don't think he filed his 22 taxes either. And so again, if they're going to ask for this offset on this judgment for the retirement account, we need to see the 2022 taxes, and I don't think those were filed. If they are, I'm mistaken, but we haven't seen them. Additionally, in here, Your Honor, there was a judgment for medical expenses. Again, Mr. Johnson terminated my client's insurance without notice and telling her she had a medical emergency.
And now the health insurance bomb. Cutting off coverage mid-divorce isn't just messy. It can be flat out unlawful under certain notice requirements. The result, more bills, more judgments, and more leverage for the wife's side.
And incurred $4,422.38 in medical expenses when she did not have insurance coverage. And again, pursuant to the notice requirement under the statute for health insurance, he was obligated to provide that, or his employer was obligated to provide her COBRA, a notification of COBRA. That was not done, and the judgment was taken. Additionally, Your Honor, there was a retroactive support judgment that's contained in the parenting plan. And there are child support guideline worksheets attached on each one of those, because again, the children were were getting emancipated and aging out throughout the course of this time. And so the child support judgment is self-explanatory. And on those notes, Your Honor, right there, again, this is a Rule 59 motion to set aside. And Your Honor is aware that on the motion to alter or amend, the only thing that this court can do is to correct errors of law or fact, procedural or evidentiary errors, clerical mistakes, or to be in the to prevent manifest injustice. So that's the standard that has to be proven, that one of those things occurred before Your Honor can alter those. So again, if you look at just the judgments that we're trying to enforce in the final decree.
And here's where it all comes full circle. Child support worksheets, the dreaded math homework of family law. Every line, every deduction, every insurance premium can shift the outcome by hundreds. It's like playing financial Jenga. And if you pull the wrong block, everything collapses.
From his $78,000, his half of the equity that's deposited with the court, the judgments are $58,514.74. And that's without post-judgment interest. He was ordered to pay child support for their one remaining minor child, and his child support obligation would have ended last month, June of 2025. His child support obligation was $775. And so I will tell you, if you want to look at the child support worksheets that are attached onto that, there was no credit for health insurance. But we don't know how much his health insurance for only the one child is. He has produced information saying he has health insurance, but the only information that he's produced post-hearing was that it cost, I think it was $330 some odd dollars. But again, that's not a breakdown, and there's no evidence or documentation from his HR to show where it came from or whether it was private pay, because we're only talking about what the cost is for this one child. And that's not been provided to us through discovery. So again, from a motion to alter or amend, if there was a clerical error because his health insurance was not included, he wasn't here to testify. And it was not there to do it. But again, what we have to do is do that. But then again, we have the secondary problem with is this man hadn't filed taxes for 2023. And so again, to reflect what his income is in 2023, because he also during the course of the marriage, he has a shade tree type business wherein he does